the motion is to have, for the defendant to force the state to amend the indictment to the charge that they believe it should be. I don't believe that is the proper motion, and amending the indictment is not the proper request before the court. I don't think there's any authority for which they can make me amend my indictment to be the charge that they insist because of a question.
The charge that they're insisting should be brought is actually a lesser included offense of the charge that the indictment states, correct?
Yes, sure.
And in the normal course of criminal proceedings, a defendant goes to trial. If there's proof that establishes it is a lesser included offense based on the facts, then the state and the defendant can either agree or they can submit it to the jury, and the jury can make an evidentiary finding one way or the other.
Yes. So now defense counsel and I have a question of law that we have discussed regarding the prior conviction. That is not what they are filing and asking the court to do, and I don't think it's fair for the court to hear it without arguments and research and things like that for the court to consider. Asking to amend the indictment doesn't answer the question of law that exists regarding the prior conviction. The defense is well aware what the prior conviction is, but asking the court to amend the indictment doesn't allow the court to hear what the argument about the law is prior to trial.
Well, I'm not aware of any law, period, that allows a defendant to request and require the amendment of an indictment. There are motions to dismiss, motions in limine, all sorts of motions that the defendant has available to them. And by denying this motion, I'm not denying the defendant an opportunity to raise the issue in an appropriate motion, but it is this court's opinion that a motion to amend the indictment, that the defendant lacks standing to bring a motion to amend an indictment. An indictment is an action of the grand jury of this county, and while the state has the right to amend the indictment as the prosecutor in the case, they require a court's agreement and a court order that allows them to amend. So for all those reasons, it is this court's opinion that I don't believe that the motion is proper because the defendant lacks standing. In addition to that, as I pointed out, the charge that the defense is arguing should have been brought in the indictment rather than the charge that is brought, which is a lesser included offense, and that's normally something that we include in the charge to the court, to the jury rather, and the jury is allowed to consider that, and they make their determination based on the evidence. But if it is such a compelling issue that at the close of the state's proof, the defendant argues that there is no evidence to support the finding of especially aggravated kidnapping, especially aggravated stalking, then they have the right under a motion for judgment of acquittal as to that charge, and the court can and might consider and grant that motion, which would then take that issue away from the jury, and they could only consider what the court found was the evidence in the case. So,
yep.
Mr.
I
Tyler,
agree.
I understand your argument, but I think that's the proper way to handle it. So. Anything else then in this? Wanted to move for a continuance?
Yes, Your Honor.
On your 412 motions, do we know a time frame for when your victim in the case or the alleged victim in the case would be available?
Well, we currently have a trial date, Your Honor, of September 24th and 25th. I hate to put a newly postpartum woman on trial for something that involves trauma. If we need to move forward that day, we can. But just whenever I would at least like to give her another week or two of rest.
When this case goes to trial, how long do you expect it to take?
Maybe a day and a half. I think picking a jury will probably take the longest, but I would want to block off 2 days just to be safe.
And how long after, of course, she's giving birth, so it's just a question of how long does she need to, how long are you requesting to put it off?
I would just ask maybe December or January.
Well,
I don't know what the schedule is.
I want to make sure we're on the same page about
I'm
what we're
asking-
talking about. There's an issue of when we're going to hear the 412 motion.
Yes.
And then there's an issue of when the trial is. And I can say with the 412 motion, anytime prior to trial will be fine. I understand the medical needs.
Yeah, we're going to first determine when the trial might be, and then we're going to, does the state have any, does the defendant have any objection to continuing the trial in view of
Yes.
all right, no objection, then the motion to continue the trial date will be granted?
Yes, we do object to the.
Oh, you do object?
Yes, sir,
All
I
right.
misspoke. My client is eager to have this done, so we ask that the trial date stay where it is.
All right. When does she give birth?
She gave birth on August 2nd.
And the trial date is set for the 24th.
Yes.
September the 5th for the motion.
Sir, I'm sorry.
I didn't know if you were
putting it in my calendar.
checking
No.
your calendar or
I'm
responding.
sick, Your Honor. I'm sorry. I'm a little dazed.
If you were on Facebook, I didn't want to interrupt or whatever. So.
Oh, yeah, I'm just cruising the interwebs.
All right, September the 5th for the motion, Rule 412 motions, and then we'll keep the trial date. Currently, we'll keep the trial date of the 24th.
Sir,
We'll see whether or not any other issues arise.
thank you.
It may require a medical proof to get a continuance if there is an issue, so
It's not really a physical thing, just a psychological thing. Postpartum.
I understand that.
Arguing that the statutory requirement of a prior conviction couldn't be met. Judge Wolfe was clear and calm in response. Defendants don't have standing to amend indictments. That power lies with the grand jury or the state, not the defense. He also explained that this type of argument is better suited for trial, if the state fails to prove the elevated charge. The defense can always move for a judgment of acquittal, and the jury can still be instructed on lesser included offenses. It was a thoughtful teaching moment, showing the court's role in keeping legal arguments in their proper lane. Then things shifted to scheduling, where the human side of the courtroom came into focus. The state asked for a continuance because the complainant had just given birth on August 2nd and would be under significant stress testifying so soon. The prosecutor suggested pushing trial into December or January, but the defense objected, with the defendant eager to keep the September 24th date for a speedy resolution. The exchange even had a touch of levity when the judge, momentarily dazed, joked about just cruising the internet as he checked his calendar. The atmosphere throughout was steady and pragmatic, no drama, just careful guidance on the law and sensitivity to the very real personal circumstances of a new mother being called as a witness. It was a classic example of how courts balance strict procedural law with the everyday realities of the people involved. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.